Capacity. The last of the 6 fundamental requirements of a contract is that of capacity. I'm going to touch on 2 areas in this podcast. The first is the situation where a party to a contract is a minor, and the second is to do with the party's mental state. In terms of minority, the age of majority in the United Kingdom is 18. And the general principle is that minors are only able to enter into contracts for necessaries. There is a class of contracts which are considered voidable, including marriage and contracts relating to an interest in land, but I'm not going to touch on them here. The rule around contracts for necessaries can be found in Section 3 of the Sale of Goods Act of 1979. This provides that where necessaries are sold and delivered to a minor, the minor must pay a reasonable price for them. Necessaries is defined as goods suitable to the condition in life of the minor and to his actual requirements at the time of the sale and delivery. The impact of this is that minors who enter into contracts which are not for necessaries are not bound by them. There is a rather interesting case on this point which perhaps demonstrates the potential unfairness of the rule. It's from the earlier 20th century, and this is the case of Nash and Inman. In this case, Inman was a university student who was under the age of majority at the time. Inman went to Savile Row, the street associated with fine tailors in London, and bought quite a lot of expensive, fancy clothes. He did not pay for them, and the tailor brought a claim for breach of contract to recover the cost of the goods. The Court of Appeal held that the goods were not necessaries because the claimant had sufficient clothes already. These were merely extra clothes. It's an interesting case because it's colourful, but one perhaps cannot help but think that it's a strange law which permits a rich, well-clothed youngster to avoid a contract, but had the individual been poor and without suitable clothes, the finding may well have been that the items were necessaries, and the poor child would have had a duty to pay for them. What's the impact of the law on necessaries? It's hard to say, as I cannot think of any case in recent time which has raised this issue. It would be interesting to create a test case and see how a court reacts. In a communications context, if a child were to buy, say, a prepaid SIM and make calls, could they claim that the contract was not for a necessary and seek a refund from the operator? In a prepaid context, the risk is perhaps low, although if a child has had a phone for many years and just before they reach the age of majority, they attempt to reclaim all the monies given to the operator over the preceding years, that might be costly. Perhaps more relevant at the moment is children buying apps or videos or music on mobile devices. Whether these could ever be considered necessaries, I'm not sure, but if they are not necessaries, there is no binding contract for their purchase. For those of you with university email addresses, I would encourage you to register, if you haven't already done so, with the Society for Computers and Law, and read the article that I've popped into the reading. It's written by Stephen Dedman, at that time senior counsel to Vodafone, on the law of necessaries and mobile commerce. The second area that I would like to touch on briefly under the rules on capacity is that of mental state, and this can be split in 2. Rules around mental illness and disability, and rules around drunkenness. In terms of mental illness and disability, if a person is unable to make a decision for him or herself in relation to a matter because of an impairment or a disturbance in the functioning of the mind or brain, that person is said to lack capacity in respect to that matter, and at that particular time. And these rules are set out in Section 2 of the Mental Capacity Act of 2005. As with minors, those with mental impairments can still contract for necessaries and must pay a reasonable price for them. Section 7 of the Mental Capacity Act. In terms of drunkenness, where a party is so drunk that they are unable to make a decision in relation to a matter, and the other party is aware of that fact, any contract which they purportedly enter is voidable, according to the case of Gore and Gibson. Since the requirement is that the other person is aware of the party's intoxication, claiming that you were drunk when you were shopping online is unlikely to get you out of contract, although fortunately you're probably still protected in many cases by distance selling rules. As with minors, someone who is incompetent to contract through drunkenness is still liable to pay a reasonable price for necessaries, again, Section 3 of the Sale of Goods Act 1979. The statutory framework expressly says drunkenness rather than intoxication, and so it's questionable whether the rules apply only to beverages rather than to drugs. However, the 1811 case of Pitt and Smith clearly references intoxication, and the same principles of public policy would seem to apply, such that it would seem reasonable to treat the word drunkenness as encompassing intoxication of whatever form, rather than simply through alcoholic intake. Although this has been relatively short, that is all I propose to say about capacity. Businesses involved in selling things to children may wish to pay particular attention to these rules, given the risk of voidable transactions, but the absence of case law perhaps suggests that, in practice, this is not a major problem.